Both please call the case.
Good afternoon, Your Honors. The matter before the court this afternoon is the case entitled Northern Security Insurance Company, Inc. versus Raymond Walker et al. Case number 24 AP 349. Representing the appellant, Ashley Moreau, as parent or next friend to Haley Moreau, is attorney Nicholas Selden. Representing the appellee, Northern Security Insurance Company, Inc., is attorney Gary Burke.
All right, thank you very much. Counsel for the appellant, please identify yourself and your client, and then you may proceed with your argument. You have 5 minutes.
Good afternoon, and may it please the court. My name is Nicholas Selden, and I represent the appellant, Ashley Moreau, and her daughter, Haley Moreau. And I will launch right into my argument now. Thank you. So I would like to start with a visual, because I think a visual is very important in this case. In this particular case, we're talking about something that happened in 1988, the date that a boat was rated its horsepower from a manufacturer, versus 2021, the date at which a loss occurred where a boat was not producing that rated horsepower. And the insurance contract has the word with, which basically says, here in 2021, we should be held to the same standards as existed in 1988 with regard to what the horsepower, the conceivable and possible horsepower was. This would be.
I'm sorry to interrupt you so soon, but I'd like to ask a question. So wouldn't the proposal you're making for a reversal here require insurance companies to go out and test motors every time there's some type of accident that potentially might or might not be covered by the insurance company?
Absolutely not, Justice Carroll. But thank you for that question. So the reason why I would say absolutely not is because 99.999% of the cases aren't this case. This case has unique facts where the evidence at issue here is actually all about what the boat was producing and capable of producing. Not even on this particular day, but at the particular, at the general time period. For the last several years that Mr. Walker owned this boat, it has never produced an amount of power that was outside of the rating. And I think what we look at as on a case-by-case basis for insurance coverage for denials is exactly that, a case-by-case basis. And so the majority of cases, maybe it's a 200 horsepower boat from 10 or 15 years ago, and maybe it's producing 100 horsepower, but clearly that's not 25.
But this is the first case like this that I've seen, with these facts, obviously. But wouldn't then anybody who says, well, I want to be covered by my insurance, I realize the policy says I'm only covered if it's less than 25 horsepower, but mine isn't. It's just not working well. It's only functioning at 10 horsepower. And they would have to go look at it and test it, wouldn't they? Every time that happens, I realize it might not happen a lot, but isn't that what would be the result here?
Well, the insured could lie about every single situation. They could lie about who's driving a particular car of theirs on a particular day. So I don't think any case would ever prevent insureds from lying. But I think, as you had pointed out, Justice Carroll, that the fact that this is a case of first impression shows that it just doesn't happen. This is not a unique or prolific issue. It's very, it's the first one that Vermont has ever seen on this particular matter, anything that's even similar to it, as evidenced by the fact that neither Mr. Burt nor I found any Vermont case law on this specific issue or anything that's really even close to it. It's just not. The defense's fears, the insurance company's fears of the floodgates breaking is not realistic. And I think at the end of the day, what's really important here is that the insurance contract is silent. It's completely silent about modifications. And so if we're tied to that original horsepower rating, why would the insurance contract be silent about aftermarket modifications that increase horsepower? And I think that is the best evidence that this insurance company and all insurance companies intended the word with to mean what it's capable of producing around the time of a loss. And the visual that I wanted to leave the court with is this is very similar to somebody applying for a UPS delivery driver job. They walk in, they ask for the job, and the interviewer sees that the person has one hand. And they say, I'm sorry, but this is a lot of heavy lifting. You need to have two hands. And he says, well, I was born with two hands, and therefore I have two hands. And clearly that's not the case. If somebody has one hand at a particular time, they're not going to have a second hand, and they are not a person with two hands. And that's exactly what this case is. This is a boat with a factual dispute as to the horsepower, and all of the evidence, every single piece of evidence says that this boat had a very poor performing motor. We have the insurance policy that is entirely ambiguous, and we were deprived of any discovery to show what Mr. Walker expected for insurance coverage, and to show the fact that he was never given a copy of this policy to begin with. Thank you. I see I'm out of time.
All right, thank you, counsel. Counsel for the appellee, please identify yourself and your client, and then you may proceed. You have
Yeah, may it please the court. My name is Gary Burt, and my client is Northern Security Insurance Company. I think this case, frankly, is quite best summed up by what Judge Battles said in his opinion below. He did not think it reasonable to interpret the phrase within the policy with more than 25 total horsepower to mean with a maximum capability at the time of loss of producing 25 total horsepower or less when measured at the propeller. In other words, what he was saying is we cannot rewrite the policy of insurance. This policy is clear and unambiguous with regard to its terms. And in fact, there's no case law in Vermont, but every other court that has addressed this issue, including the Safeco decision, has held that the language within the policy is unambiguous. They have even applied it to a situation where the boat was in dry dock at the time it caused the injury, and thus not on the water. The court said that doesn't matter. It still had the total horsepower of more than 25 horsepower, and thus no coverage could be afforded because it didn't fall within the exception to the exclusion. The language here is quite clear and unambiguous, and as was suggested, any other interpretation or the interpretation suggested by my learned opposing counsel would require each time a loss occurs involving a motorboat to go out and determine whether at that time of loss it had the capacity to produce more than 25 horsepower, total horsepower. And so, as the court in Safeco said, this approach would work to the possible detriment of both the insurer and the insured, in that neither would know whether the coverage was available until post-accident testing and evaluation had occurred. And that's something that I don't think any insured wants to have happen, and certainly the insurer. I think another better example is what happens if I have a boat that in the morning is running really well and therefore is producing more than 25 horsepower and has that capacity, but in the afternoon, for whatever reason, is not running that well. And so it cannot produce in the afternoon that level of production. Does that mean that in the afternoon there's no coverage? There is coverage, but in the morning there was not coverage? I mean, you could have a situation conceivably where a boat would be covered for 1 hour and not covered for the next hour if you got that situation happening, or 1 week and not the next week. There would be no understanding as to when the boat was actually covered if you apply the construction that's suggested by the appellant here. And it's simply a rewrite of the policy. It's, as we might say, forcing an ambiguity onto the policy that does not otherwise exist. And that's what all the other courts have held. Like I said before, universally, this exception to the exclusion has been applied as written, and it says if the horsepower of the engine exceeds 25 horsepower, then there is no exception to the exclusion under the policy. I will entertain any questions that you might have.
All right, I don't see that anyone has any, counsel.
All right, then I'll stand on my brief. Thank you very much.
All right, very well. Bailiff may call the conclusion of the case.